Also, madam.
Let me just find out two. A report was called for in two also, right?
Yes. 2, 4.
Oh, the earlier date also you sought accommodation. A report was called for recording the statement of the de facto complaint.
Yes, my statement has been recorded by the investigating agent.
So the report is on its way.
On the.
I'm just passing it over. Please come back.
I am for the private respondent.
To lordship, this is that matter lordship had placed to direct the parties to make an amicable settlement. So my client is appearing. Lordship, one of his family member had demised last week. They have also decided that lordship. Can you see
Oh,
the?
you wanted to take instructions.
Yes,
You need some
she
time.
has already come, lordship. Now, the thing is that lordship that compromise cannot be sorted out because she has some reservation to go to the house of the petitioner accused person.
She has some reservation.
Yes, yes. So she wants to say something, lordship, if you lordship, permit.
I'll ask কি নাম আপনার? আপনি উপরে উঠুন। কি নাম আপনার? এই মামলা আপনি করেছেন? আপনাদের রেজিস্ট্রেশন হয়ে গেছে বিয়ের? আপনি শ্বশুরবাড়িতে ফেরত যেতে চান? আপনি কম্প্রোমাইজ করতে চাইছেন না, তাই তো? কিন্তু আপনি এর আগে একটা এগ্রিমেন্ট সই করেছিলেন যেখানে আপনি বলেছিলেন যে আপনি এই বিষয়টা নিজেদের মধ্যে মিটমাট করে নিতে চান। There was an agreement.
Yes.
এরকম একটা এগ্রিমেন্টে সই করেছিলেন আপনি এর আগে?
না ম্যাম, তো এই এগ্রিমেন্টে সাইন করেছিলেন যেটা তো কম্প্রোমাইজ হয়েছিল নোটারির সামনে, নোটারির কাছে।
তখন আপনি বলেছিলেন যে আপনি সংসার করতে চান আপনার স্বামীর বাড়িতে গিয়ে। আচ্ছা, ঠিক আছে, আপনি নামুন। Cannot be affected.
These are not allegation for 76, the 498 case.
That will be
She
dealt
had
with
gone
on
to a
merits.
matrimonial house, he could not stay there.
The
Whether it's
compromise
76
cannot be
40,
affected. That can be dealt with on merits. I'll not go into
Yes.
merits at the moment.
kindly
Let it appear before the next circuit. I'll appear.
let the interim order be got.
There is an interim order.
Yes.
When did it expire?
So there was no
Where is the interim order? When was it passed?
time of expired. So kindly right
Up to the next date when the court shall take up this matter for hearing.
Yes.
So it is continuing. Or well, I'll extend it for a limited period. The petitioner, the private opposite party is present in court and submits that she no longer intends to settle the matter mutually with the petitioners, since petitioner stop me. She submits that pursuant to the it's a memorandum of compromise. What was the
No, only a declaration, sort of a declaration executed before the notary.
pursuant to the agreement for compromise executed by and between the parties, comma,
Only an affidavit,
She-
not a.
pursuant to the affidavit sworn before the sworn by the parties, comma, she went to her matrimonial home but was ill-treated and tortured by the petitioners therein. Paragraph. Since the private opposite party is not inclined to settle the matter amicably, comma, the matter be heard on merits. Paragraph. the revisional application be placed before the next available circuit bench. Paragraph, the interim order granted earlier is extended till 31st January 2025 or until further orders, whichever is earlier. Next,
Great Fuller.
But in item 4, madam, we are also waiting for.
I am for the
report, madam.
private respondent.
I'm for the petition.
Compromise.
Compromise.
the report is on its way, I believe. I'll just pass it over.
Mild.
Yes, yes, yes.
Next,
Matter 6, I am for the petitioner. This is the 498 matter, compromise matter. Your lordship, earlier occasion asked for a report from the state matter.
কত number?
6. 6 আর 7.
yes, Mr. Nila Chakraborty was requested.
তো কালকে রাখ,
Well,
or kindly make it not today.
Not.
Tomorrow is the last day. Please
Yes,
get the
that's-
report
that's
tomorrow.
true, madam.
A compromise matter
Ah,
did
yes,
not
yes,
be
yes,
withheld.
yes.
Not today.
I don't have 7 or tomorrow.
7, you have the report?
7 joint.
Oh, joint from.
You have the report?
No, madam.
Please get them by tomorrow. 6, 7, not today.
Get.
That one কত বার? That one, okay.
Any time for the petition.
কোথায়?
So Aniruddha Vishwas is there for the prosecution. It can be taken, short parcel, but. Perhaps he is like,
This is at the motion stage.
no, bail matter,
Oh, oh, this is a bail matter.
bail matter.
Who is appearing for the state?
Aniruddha Vishwas. I'm told that one.
Where is he?
Third is report number 1, madam.
Passed over.
Lost.
Is the CD there? Are you aware? Nine,
No, Mr. Subhasis Mr. will appearing in the case, madam.
9.
Kindly, yes, kindly make it short parcel.
Petitioner is not there. None appears for the petitioner, no accommodation is sought. The matter be placed before the next available circuit bench. Next,
Lordship, item number 10 is for extension of interim order.
have you served?
Lordship,
They've refused. But that's good service.
Lordship,
You have the affidavit of service with you?
Lordship.
বাধাবাধি গুলো পরে করুন, ফাইলটা দিয়ে তারপর করুন। আমি বসে থাকবো আপনার জন্য। Yes, raise your affidavit of service.
Lordship. Affidavit of service.
All of them have refused. They are from the same house,
Lordship,
all the opposite parties,
all the opposite.
because I find 2 have not been served.
Lordship.
Two refused?
1 and 2 have refused and 3 has left the address without instructions.
And 4 is also not served. Did not
There are
complete
only
the
3
service.
parties.
Oh, yes. I'll extend this for a limited period. Affidavit of service. Paragraph, the interim order granted earlier. The interim order granted earlier is extended till
That's number
31st January 2025 or until further orders, whichever is earlier. Can dispose of, CO. Can, see, can dispose of. Next,
11 lordship. Congress is appealing for the opposite party to short parcel.
extension. of it.
Extension of it.
Why do you require a pass? File the. Service complete?
Yes. Anybody?
Oh, you are appearing. Let me extend this for a limited period.
Lordship.
Within time, when was it passed?
Yes, within time. 28, it was filed on 28th of November.
Affidavit of service. The interim order granted earlier is extended till 31st January 2025 or until further orders, whichever is earlier. Can dispose of it or COP. Can one with dispose.
Great, Lord.
Next, contempt of whose order? My order.
Lordship's order. Delivered, Lordship. Your Lordship kindly come to page number 14 of the application.
Have you served?
Yes.
Give me a minute, please. The service, the postal receipt doesn't match with the. Oh, it's 833 and 847. I do not find anyone for the state. He's representing the state, isn't it? Forest Division.
Yes, first, the. Last. From the contempt order.
Yes, anyone for the state?
Your Lordship directed to consider my representation in terms of the rules. West
That was
Bengal.
not done.
That is not been done.
Who was representing in the application?
Yes, Mr. Saurabh, Mr. Aditi Shankar Chakraborty and Mr. Saurabh Ganguly. I informed them, Lordship.
Since service is there, I need to issue rule actually. Mr. Ghosh. A contempt application, you are not appearing in this matter, but then Forest Division, the main matter was represented by Mr. Aditi Shankar Chakraborty and.
Resigned from the state panel 1 year back, August 2023.
Oh, really? Okay.
But I'm sorry.
Where are the state people? I do not find any
Well,
of
I'll
them.
just look.
This is a contempt application. I have to issue rule.
What department?
Forest Department. Hospital.
The CRM
Then
was Mr. Aditi Shankar Chakraborty and Mr. Saurabh
Well,
Ganguly.
I'll just inform someone in the.
I'll pass it over. Let me
Pass
see.
it on.
Okay.
So please inform one of them. Let them
Lordship.
come and tell me what's happening. Yes, next.
Admission. Admission for. This is the
Within
third
time?
occasion. Well, there is no representation from the state. I'm being, it's against the order of a judgment and order of an acquittal. I'm suffering for a year.
It's an order of acquittal.
My lord, I have been informed by the persons who were acquitted, my lord, these and alleged
Yeah.
persons. But I am yet to meet them. They are supposed to come today. So it is a application for.
Condonation of delay of 258.
Oh, there's a condemnation
My
application.
my lords.
Have you served the copy?
My lords, I have served twice. Subsequently, this honorable court instructed the state advocate to inform the
To serve.
accused persons. My lords, there are two evidence of service, your lordship. My lords, they are representing.
I-
Lords,
Have the copies.
Who is representing the private opposite party?
my lords,
I am on behalf of the private opposite parties, my lord. I need to get the documents. I don't have the documents.
What documents do you require for a section 5?
At least the petition, my lord, by the.
Let the section. You have received copy.
twice they have. Even state has served.
How many days delay? 258
Two.
days. I'll allow the section 5.
Ah.
Fight it out on merits.
As you have.
My lords,
Please serve the main application. I'll give a direction.
my lords, that can be. we cannot give the copies of the.
I know, I'm giving a direction to that effect. Yes. Heard learned counsels for the parties. Ran one. No? The appellant seeks condonation of delay in filing the appeal. Paragraph. Heard learned counsels for the parties. Good grounds being shown, comma. The application is allowed. Paragraph, delay in filing the appeal is condoned. CRAN 1 of 2023 is disposed of.
My lord,
Appeal has to be admitted first and then you have to serve, not at this stage. I've disposed of the CRAN.
so it will be coming under the heading of admission.
Yes, yes.
Lordship, for item number 14, I beg to appear virtually.
Yes.
Lordship, in item number 14, your Lordship has directed to file a joint compromise petition in this matter. But Lordship, one difficulty we have been facing is that the husband, who is not the petitioner in this matter, is residing in Hyderabad, whereas the wife, who is the opposite party number 2, she is residing in Bangalore. So they couldn't come in a very
You
short
need
notice.
some time.
Lordship, just one submission I would like to make. The petitioners in this matter are the in-laws of the husband, your Lordship. So if your Lordship may
It was
consider.
your submission that you wanted to amicably settle them. It was settled.
Lordship, if the agreement has already been made in this matter, they are settling it after their divorce. So if your Lordship may consider this matter.
How do I consider without a joint application?
Then
Because
Lordship,
it was
I.
your submission on the earlier date.
Yes,
That
your
you
Lordship.
wanted to come back with a joint application, right?
Yes, your Lordship. But that difficulty that I am facing, that both of them are not
You may
present.
be ready by 2nd January, by the next circuit.
Your Lordship may fix it for 26th of January then, because their divorce will be completed and the settlement will also be
I cannot
completed by
fix
then.
a date when I'm not there. I'll allow it to be placed before the next circuit.
Oh, grateful, your
Try and
Lordship.
come back.
Grateful, your Lordship.
On prayer of the petitioners, the matter be placed before the next available circuit bench. Next.
Lordship, before the next, item number 12, Mr. Ganguly is here.
15, item number 15.
The contempt matter. Mr.
Yes.
Ganguly is here.
You were in the main matter.
Yes,
The
sir.
contempt application has been served. No one is appearing, so I have to issue rule.
Lordship, they have handed over copy to me now.
You are not instructed, I understand, because this is a contempt application.
Lordship, can it be fixed tomorrow? May I get a little
Not
instruction?
today.
Lordship. Copy the- the copy the-
Served.
Lordship.
Take
Lordship, it is
advance,
served
please
upon
take an advance
Withdrawal
copy.
division, but the cases of Kashyang division.
Then you've served the wrong division.
Lordship, can you see the councillor? Now that's the problem.
You have to make a proper service. Make
Huh?
a file.
Lordship, this was served upon
12
Withdrawal
and 5
division.
My lord, the two division has been merged into the Karsang division, but they have not able to provide the details of the office. Therefore, the copy of the order was communicated to the Vaikuntapur division. Now this.
No, Vaikuntapur division was
This
not
is
there.
a
Now this
contempt
com-
application
contempt
where the
application has-
person is personally liable. So if it's served on the council, it will not help. You have to serve the person
Well,
personally and
this
come back.
copy has been personally served to the person who is responsible for that.
By name it is served.
Lordship, I see, I did the.
But why has he received it?
Contempt order.
He has received the copy,
My lord, may one day.
not today,
I have to copy
Grateful, my lord.
not today. Next,
There was a pastor matter, Lordship.
I'll complete the list and call pastor.
Lordship, item number 15, can you fix on a next
15.
next circuit, Lordship, because of next Friday.
You are the petitioner.
I am.
Amna, 15 on prayer of the petitioner, the matter be placed before the next available circuit bench.
I am for the petition. But on the last occasion, as the private respondents, they were not appearing. There was a direction to the police authority for making the
Sir,
search.
Aniruddha Biswas, where is it?
But what I did, I found that I called the police station and I found that it was not there. So on Saturday, I gave the copy of the petition and also the order of
To the
this
PS.
to the PS. And I requested them and they have served to the respondent. They have called, the IC has called me personally that it's being received.
There
This
should
is-
be a report from the state.
Absolutely. I have that document also, my lord, which the receiving of. And the private opposite party also, they called me, my lord.
But I have to check the CD.
So what is left? Private opposite party also called you.
My lord, for understanding what to do, I said they need to come here and appear on Monday. This was what they were seeking, and I just informed them.
I have to find out the CD. Has been received or not in the office.
The pain is, my lord, this is if I may be allowed to place my case, my lord, your lordship will understand that people who are there, one of the petitioner is an officer of SSB who is working in Bhopal. And another officer, he's a retired accused person is a retired Air Force officer who is serving the SBI right now. My lord, these people are resident of a particular place, a particular apartment or a society, that is Vastu Vihar in Siliguri, my lord. One night, my lord, there was a lot of noise. Two people in extremely drunken condition, they were fighting with the employees of the Vastu Vihar for the purpose of water logging. There were some female staffs also. So to rescue them, these people intervened because they also have their flats there. The police was called, the police came, and the police asked to make a formal complaint on the next day. On the next day, these private opposite parties approached the management and they have given a maafinama also. That but then the formal complaint had to be made by the management. After the formal complaint was made, the next day, this complaint under SC/ST was made that they have abused them, but this is not the fact. And moreover, my lord, going to their house after they open their door, if at all for argument's sake, it is considered that they spoke something, then also it does not.
I understand, but I'll require the report from the off service.
Not,
From the state. So I'll just make it not today. Will you come back with the report tomorrow?
not. I will
Only not
find out.
As you
Right now, I'll find out.
Not today.
17, my lord, I appear for the petitioner.
Lordship, I am for the petitioner. Senior advocate will appear virtually.
No,
He's in
not
virtual
senior
mode.
advocate. I have not been
Yes.
designated, my lord. Not senior advocate. I apologize, my lord, on behalf of my advocate on record. My lord, I appear for the petitioner, my lord.
Yes.
My lord, the petitioner, my lord, this is a case. The petitioner was serving as a revenue officer under the BL and LRO Dhupguri office, my lord. Mutation case was filed. Mutation was done in favor of the other private opposite parties. Now, the petitioner, my lord, here is aggrieved by this mutation. And then, my lord, he files a police complaint. The police files a charge sheet, my lord, under section 420, 468, 471, 120B, 219, and 34 of the Indian Penal Code. Now, my lord, here, my lord, in the preliminary stage, my lord, my submissions is that, my lord, no sanction has been taken under 197 of the section 197 of the Code of Criminal Procedure.
Please
my lord.
increase your volume. You're not properly audible.
Now, my lord.
Yes, yes.
Yes. So, my lord, I was discharging my official duties as a revenue officer under BL and LRO Dhupguri, my lord. Now, a mutation case was filed. Mutation under notices were serviced. Mutation was effected in favor of the other opposite parties. The petitioner, my lord, is aggrieved by that mutation. Now, instead of filing an application under the West Bengal Land Reforms Act,
Cannot be agreed. The opposite party is agreed by the mutation, right?
sorry, the opposite party. I'm sorry, my lord, I stand corrected.
Yes.
Now, my lord, the opposite party files instead of filing a appeal under the West Bengal Land Reforms Act, files a police complaint, my lord. Now, here at this initial stage, my submission is that, my lord, an appeal can be filed. It has not been filed. No sanction under section 197 of the Code of Criminal Procedure was obtained. Further, my lord, under section 58 of the Land Reforms Act, if I have discharged my duties on an official purpose, my lord, there is a kind of immunity against proceeding against me, my lord. Now, here, lordship, this is a completely frivolous application. No case has been made against me. If at all, my lord, the opposite party is aggrieved, my lord, I repeat, my lord, he has a remedy under the West Bengal Land Reforms Act to prefer an appeal. I was discharging my duties, my lord, in my official capacity.
Investigation is going on?
My lord, charge sheet has been filed on
When is the
27. Next date, my lord, is 29th of January 2024.
So serve and come back. I'll place this before the next circuit.
Yes,
Next
my lord,
circuit
and my
is
lord,
taken.
my lord, I am praying for a limited protection, my lord, because in the charge sheet, my lord, I have been shown
You
as
are
an
on bail.
absconder.
You are
No,
on
no,
bail.
I am not. No, I am not even on bail, my lord. I have not even applied for bail. I was not arrested, but I have been shown as an absconder, my lord. Even though, my lord, I am discharging my official duty now in Bijanbadi. The charge sheet, my lord, is at page 30. I'm sorry, my lord. Charge sheet is part of the
Certified copy. I've seen. Yes.
certified copy, my lord. Yes.
Warrant has been
I have been
issued.
shown.
Warrant has been issued.
Warrant has been, my lord. Prayer has been made. Next date is for service return, my lord. That order,
Summons was issued,
yes.
not warrant, right?
No, no, warrant we have not received, my lord.
I do not find that order sheet also. Have you annexed the order sheet?
Yes, my lord. I have. Kindly sees page. My lord, that is also part of the certified copy.
Yes, I've seen that. Summons has been issued.
Yes, my lord. Summons have been
Why don't
issued.
you appear before the court? Serve and come back. I'll fix this before the next circuit. Appear. You'll have the next circuit even before the date of appearance, right?
Yes, that I have, my lord. That I have.
See, you don't need to stay at the moment. And there is no
As a
warrant
lordship.
against
No, as a lordship. And my lord will kindly not take my learned advocate on record amiss. He referred to me as a senior advocate. My lord, I am not.
That's fine. You are senior to him, you're his senior. He meant that must be.
Yes, my lord. He meant that, but then my lord knows.
No difficulty. The petitioner seeks quashing of GR case number 5947 of 2024, pending before the learned Chief Judicial Magistrate, Jalpaiguri, primarily on the ground that no sanction was obtained under section 197 of Code of Criminal Procedure before proceeding against him. Stop. The petitioner is an employee under the Block Land and Land Reforms Officer and has acted in his official capacity for mutation of the property in question in favor of the applicants. Instead of challenging the said mutation under the West Bengal Land Reforms Act, the private opposite party has lodged the present complaint against the petitioner and others. Charge sheet has been submitted, charge sheet has been submitted and summons issued upon the accused persons, including the petitioner, fixing 29th January 2025 for service return. Paragraph, the matter needs to be heard on merits. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the next available circuit bench.
Grateful, my lord.
Next. 197.
18 lordships, I have instruction to withdraw, not place the I am the advocate under particular.
Learned counsel for the petitioner submits that the petitioner does not intend to proceed with the matter any further. Paragraph in view of the above, the revisional application being CRR 430 or 88?
Yes.
488. 488 of 2024 be dismissed for non-prosecution. Paragraph, there shall however be no arrest to cause as the certified website. Next.
Item number 19.
No.
Lord, in 19, I appear for the petitioner.
I am appearing for the state.
My lord, this is a revisional application. My lord, assailing an order of, my lord, conviction passed in an appeal proceeding. So, my lord, the petitioner happened to be first convicted by the Court of the Learned Judicial Magistrate First Court. Thereafter, his conviction was upheld by the, my lord, Sessions Judge. My lord, against that, I have preferred this revisional application. Now, my lord, he has been convicted only under one section, which is 323 hurt, and he has been sentenced to an imprisonment of 3 months. My lord. Now, my lord, my prayer before your lordship is only beneficial, because, my lord, the incident dates back to the year 2011. Today we are standing here in 2024, 13 years after the incident. Now, my lord, his appeal has been, the conviction has been upheld, but your lordship is empowered with section 357, 360 subsection 3, and my lord, section 4 of the Probation of Offenders Act, wherein, my lord, in a similar situation, your
That's
lord,
discretionary.
yes, my lord,
That's discretionary.
yes, my lord, I'll place a Supreme Court judgment wherein a similar circumstance, the Supreme Court was, my lord, pleased to, my lord, extend the benefit of this section 4 of Probation of Offenders Act. Lord, kindly takes up the act once. Lord, section 4(1). It is at page 6, my lord.
Yes.
Lord, it says, where any person is found guilty of having committed an offense, not punishable with death or imprisonment for life, and the court by which the person is found guilty is of the opinion that, having regard to the circumstances of the case, including the nature of the offense and the character of the offender, it is expedient to release him on probation of good conduct then, notwithstanding anything contains a non-obstant clause, my lord, anything contained in any other law for the time being in force, the court may, instead of sentencing him at once to any punishment, direct that he be released on entering into a bond with or without sureties to appear and receive sentence when called upon during such period, not exceeding 3 years, as the court may direct, and in the meantime to keep peace and be of good behavior. Now, this is a beneficial legislation. And, my lord, in a similar circumstance where the incident, my lord, dated back 10 years, the Supreme Court was, and my lord, the accused, the petitioner in that case, was, my lord, convicted under section 325, grievous. Now, my lord, in that circumstance, I'll place that judgment.
Are you ready for the hearing?
Yes.
Lord, I'll not trouble your lordship with the facts of the case. My lord, he was convicted under section 325. Kindly comes to para 27 at page 5. My lord. It says the learned counsel appearing for the accused submitted that the incident is of the year 1990. The parties are educated and neighbors. The learned counsel therefore prayed that the benefit of Probation of Offenders Act 1958 may be granted to the accused. The prayer made on behalf of the accused seems to be reasonable. The incident is more than 10 years old. The dispute was between the neighbors over a trivial issue of cleaning of drainage. The incident took place in a fit of anger. All the parties are educated and also distantly related. In my case, my lord, we are directly related.
You are?
Directly related. We are relatives. The incident is
Please
not.
please come to the circumstances of your case.
Yes, my lord. I'll come to it. Lord, kindly comes to the judgment passed by the appellate court. My lord, it is at
Yes, the certified copy.
page 64, my lord. I have annexed it as an annexure,
Yes.
page 64. My lord, page 65 is important, which states the history of the instant appeal. May I read, my lord?
Yes.
It says the de facto complainant Kumod Rai filed a written complaint at Bagdogra police station alleging that the appellant and others had forcibly possessed the land of his deceased uncle and used to cultivate such, and wherever the de facto complainant went to cultivate the land of his deceased uncle, which he possessed, the appellant convict used to threaten him. On 30th day of November 2011, at about 8 a.m., the appellant began to cultivate the land possessed by the de facto complainant, and when he objected to the appellant, came from behind and assaulted him on his head, for which he fell on the ground unconscious. The written complaint was registered as Bagdora Place case number 318 of 2011, dated 1st of December 2011, from which the instant case emanated. Investigation commenced and culminated into a charge sheet under sections 447, 341, 325, and 34. These were the charges, my lord. The charges were also framed under these sections, but he was ultimately found guilty of section 323. Now, my lord, takes up, my lord, page 66, which discusses the evidence. I'm sorry, my lord, page 67.
Yes.
Para 5, my lord. First and foremost, I proceed to look into the medical evidence to decipher as to whether the prosecution had placed any document showing injury to the alleged victim before the learned trial court. The learned trial court in page 14 of the judgment had stated that after scanning the sections, it appears the report of the doctor and evidence of the witnesses, it was proved that there was cut injury on head bilateral, which falls under hurt, and it is proved by the corroborative evidence of PW1 to PW6 along with PW7, and the injury report is marked as Exhibit 2, and defense by their own argument and cross failed to break it, and also corroborated by his own witness as DW2, who is independent witness, who admitted about the head injury of the de facto complainant. Therefore, it appears that the prosecution had brought forth the injury report purporting to be an injury report of the de facto complainant victim. I have perused the injury report being Exhibit 2, and it appears that the Assistant Medical Officer of Bagdogra PHC had examined the de facto complainant who was brought by Budhir Roy, a history of physical assault on 30th November 2011 at 9 a.m. From the injury report, it appears that there was a lacerated cut injury on the occipital region, and 4 stitches were given. I proceed to look further into the evidence led by the attending doctor. Now, my lord, thereafter, the attending doctor, being page 68, my lord, Dr. Deepak Kumar Sadhu, adduced evidence as PW7, and in his examination in chief, he stated that on 30th of November, he was the medical officer at BPHC and had examined one Kumar Chandra Roy, who was bought by Budhir Roy, and on examination, he had found an injury on the occipital region, and 4 stitches were given, and was advised to be admitted at NBMC hospital if the patient fell unwell. The witness identified the injury report prepared by him, which was marked as Exhibit 2. I have perused the cross-examination, and there was no cross-examination to dispute the identity of the patient. The cross-examination pertained only to the non-fulfillment of the format. The witness was also cross-examined as to non-mentioning of the depth of the cut injury. Therefore, from such evidence, it appears that the prosecution had proved the existence of the injury report of the de facto complainant being the victim, and which was written by the doctor within a short span from the alleged time at which the incident occurred. Hence, I am in consonance with the observations of the learned trial court as regards the existence of the injury report. So, my lord, the injury report was, my lord, proved. Now comes to, my lord, page 70, the last paragraph.
Yes.
Page 70, the last paragraph, para 12. PW4 had also stated in his examination in chief that the accused persons had come to cultivate the land on a day, and his brother, being the de facto complainant, objected, and thereafter Upen assaulted him, causing injury to his head. I have perused the cross-examination, and it appears that there is no cross-examination to negate his presence as asserted at the PO, and of him witnessing the alleged incident. PW5 also stated that about 4 years ago, the accused persons had went to plow the land of her husband and her bhashur, being the de facto complainant, and raised objection, and when Upen assaulted her bhashur with a lathi, and the victim was taken to the hospital. In the cross-examination, it would appear that the asserted presence of such witnesses was not negated by the learned advocate for the accused. The learned trial court had correctly opined up the corroboration of the evidence laid by the witnesses. It also appears that the learned trial court had correctly come to the conclusion that the defense witnesses failed to break the statements of the PWs. So, my lord, this evidence shows that the, my lord, accused persons and the de facto complainants are relatives, and a scuffle broke out with regard to cultivation of a particular land, which both of them claim to be their own, and a civil suit is also pending. I'm not coming into that, my lord. The background of this dispute is civil in nature. It was attempted to be brought into the evidence by the defense counsel. However, my lord, that was not given much regard to by the learned courts below. So, my lord, the scuffle broke out with regard to cultivation of the land and the victim suffered injury. I am not into the merits of the case, my lord. The incident dates back to the year 2011. We are 13 years after that. I am only seeking, my lord, the extension of the benefit under Section 4 of the Probation of Offenders Act, as well as, my lord, Section 357 of the CRPC, which states that, my lord, if I am ready to pay an enhanced fine, that can also be made a ground to, my lord, reduce my punishment and, my lord, suspend my sentence. And, my lord, another very important factor is, my lord, the petitioner is 66 years of age. So, my lord, that
Age will not be of aid to him.
Yes, ma'am,
66 years old.
my lord, that is in 360 subsection 3 of the CRPC. I'll come to that. Section, my lord, 363 of the CRPC, which is presently 401 of the, my lord, Sanhita, kindly takes up, my lord, once. Section 360, subsection 3 of the, my lord, CRPC.
Yes.
It says, my lord, in any case in which a person is convicted of theft in a building, dishonest misappropriation, cheating, or any offense under the Indian Penal Code, punishable with not more than 2 years imprisonment, or any offense punishable with fine only, and no previous conviction is proved against him, the court before which he is also so convicted may, if it thinks fit, having regard to the age, character, antecedents, or physical or mental condition of the offender, and to the trivial nature of the offense, or any extenuating circumstances under which the offense was committed, instead of sentencing him to any punishment, release him after due admonition. Now, my lord, subsection 4 is also very important. An order under this section may be made by the appellate court or by the high court or court of session when exercising its powers of revision. So, my lord, this court is also empowered with the same powers. My lord, I am only seeking extension of these benefits. Considering the circumstances and a trivial dispute broke out of which, my lord, the de facto complainant, the victim, suffered injuries, I am ready to, my lord, pay an enhanced fine because the fine imposed by the learned appellate
1,000.
is only 1,000. I am ready to pay a fine of up to rupees 10,000, my lord, but, my lord, I may not be, my lord, sent to jail for this.
My lord,
Yes.
after this submission, my lord, I can only say one thing, my lord. All the witnesses, including the de facto complainant victim, corroborates with the prosecution case exactly. Now, kindly see from page
He's
16.
not on the conviction.
Yes,
He's on the sentence.
yes.
A
Up-
323 matter,
Yes.
3 months was given.
That's true. Your
Let the
lordship.
fine amount be increased, let him be released on probation. Yes,
Up to your lordship.
I'm deeply.
Only note my formal objection.
I will.
Very good.
কিন্তু সাইড দিয়ে বেরোবে এরকম কিছু নেই। যেন বললাম বড় ভাই বলতে মামলা করা উচিত।
The petitioner
আমারটা পেয়েছেন আমারটা?
who has been convicted for offense under section 323 of the Indian Penal Code and sentenced to suffered imprisonment for 3 months and pay fine of rupees 1,000 has assailed the judgment passed by the learned Additional Sessions Judge, Fast Track Court, Siliguri in criminal appeal number 18 within bracket 5 of 2016 on 13th November 2024, affirming the judgment of conviction dated 19th March 2016, passed by the learned Judicial Magistrate, First Court, Siliguri in the GR case number
My lord, GR case number is 2651 of 2011.
In GR case number 2651 of 2011. Paragraph, learned counsel for the petitioner submits that the petitioner and the de facto complainant are relatives and the alleged incident is a result of a scuffle between them on the issue of cultivating a land which both the parties, of which both the parties claim to be owners. The incident occurred on November 30th, 2011. And the petitioner suffered the ordeal of criminal trial for about 13 years, right?
Yes.
13 years. Learned counsel submits. The petitioner prays for his release on probation under the Probation of the Probation of Offenders Act, 1958. Paragraph, learned counsel for the petitioner further submits that the petitioner is ready and willing to pay an enhanced fine and be released on probation in view of the trivial nature of the offense and the period of sufferance of the petitioner. Learned counsel has placed reliance on the authority in this is not a reported judgment.
Yes, the my lord, citation is at the top.
Authority in State of Maharashtra versus Jagmohan Singh Kuldeep Singh Anand, reported in 2004 within bracket 7 SCC 659. Paragraph, learned counsel for the state opposes the prayer. Paragraph, it appears that the alleged incident occurred on November 30th, 2011. And the case was registered on December 1st, 2011 under section 447, 341, 325, 34 of the Indian Penal Code. How many? Only one petitioner?
Yes.
One accused?
Yes.
One person is convicted.
The rest have been not let off.
Acquitted?
Yes.
Charges were framed under section 447, 341, 324, 34 of the code, C capital. And upon recording evidence of witnesses, the learned trial court convicted the petitioner for offense punishable under section 323 of the code of 323 of the Indian Penal Code and sentenced him to suffer imprisonment for 3 months and pay a fine of ₹1,000, in default to suffer simple imprisonment for another 15 days. The other accused were found not guilty and acquitted. The petitioner carried the judgment in appeal and by a judgment delivered on 13th November 2024 in criminal appeal 18 within bracket 05 bracket closed of 2016, the learned appellate court affirmed the judgment of the learned trial. Paragraph. It appears that the alleged incident was a result of a dispute between the parties with regard to cultivation of a land of which both the parties claimed to be owners. Stop. The petitioner has suffered the ordeal of the criminal proceeding for about 13 years. Stop. Paragraph. Jalpaiguri. The parties are related to each other. Paragraph. In view of the facts and circumstances of the case, as well as facts and circumstances of the case, open ad column, as well as stated, as recorded by the learned trial court as well as the learned appellate court, comma. This court is of the view that the petitioner may be released on probation by directing him to a 1-year bond,
Yes, ma'am.
execute a bond of 1 year for good behavior, should be subject to satisfaction of the trial judge, right?
Yes.
Subject to satisfaction of the learned trial court. Paragraph, in view of the above, comma, the revisional application being CRS such and such is allowed. Paragraph, the judgment delivered by the learned trial court on
Okay. The trial court's judgment is 19th of March 2016.
19th March 2016. In GR case number 2651 of 2011. Insofar as imposition of sentence upon the petitioner and the portion of the judgment of the learned appellate court in criminal appeal 18 within bracket 05 of 2016, delivered on 13th November 2024, affirming the said sentence be set aside. Paragraph, the petitioner be released on probation. Language table. Upon execution of bond of 1 year for good behavior, subject to satisfaction of the learned trial court, the petitioner shall also pay fine of rupees 5,000. 5,000 within a week?
Yes.
Within a week from date.
And our objection
Failing
part
which-
only,
I've
kindly
recorded-
add, yes.
I've recorded. Failing which the sentence imposed by the learned trial court shall revive.
Just one indulgence, will not be bond part, it may be kindly notified as personal bond. Because your lordship has not directed any sureties. So not this bond may be interpreted otherwise by the. That's maybe
Personal bond.
person.
দু জায়গায় বলেছি বন্ড, বন্ডটা পার্সোনাল। আগে প্যারাগ্রাফে বন্ড।
Deep proportion. Very good.
Parties to act on the server copy or urgent certified website copy. Next.
I'm for the petitioner lordship.
Oh, এটা রাখ। আমাকে বলছি, if you do this. Yes, 20.
Motion. Lordship, I am the ostensible owner of two vehicle, which was financed with a financing company. I had given this vehicle to the opposite party number 2 to use it on a formal, in an informal terms. Lordship. Subsequently, he claimed to be an owner, and that's why the dispute cropped up, and I approached to the learned magistrate and seeking a search warrant against that particular vehicle, and police has registered a case on at the behest of mine, and lordship subsequently search warrant was issued pursuant to a direction of the learned court below, and search was conducted and seizure and the vehicle was seized under the from the opposite party number 2, and subsequently it was reported to the learned magistrate. Upon furnishing due bond, lordship, I got back the possession of the vehicle. On that particular same day, on the very same day, the same police station, the opposite party number 2 approached with the impugned proceeding, claiming that he is the owner, and that's why he needs the vehicle back. This is his complaint. Lordship, I would like to visit your lordship, kindly see at page 27 of my application, where I initiated the proceeding under section 94 of the Code of Criminal Procedure, and the consecutive order was passed. Subsequently, lordship, the seizure list at page 29 of my application, which ipso facto indicates that the possession of the vehicle was taken off from the opposite party number 2, page 29 and 23, and subsequent thereto, lordship, at page 34 of my application, kindly see the police has forwarded the vehicle to the concerned to the learned magistrate, where it has been categorically observed, lordship, the last paragraph, that at this stage I have no objection to release the recovered 2 numbers of vehicle bearing registration number so and so.
Page?
Page 34. Page 34. Last paragraph. The police observed that I have no objection to release the recovered 2 numbers of vehicle bearing number so and so to its registered owner Arup Rahat, here the petitioner. As your lordship, as your court made him fit and proper. Lordship, this is report updated 3rd of April 2024. Now, the impugned FIR has been registered on 4th of April, which is the next day.
When was the vehicle returned?
Returned on the 4th, because
The same day?
no, the 3rd it was report was forwarded on the
And 4th it was returned?
yes, that order sheet is the 4th of April, 4th of March, the order sheet at page 32 of my application.
Search warrant was issued.
Yes. Fourth of April, kindly see at page 33.
Yes, it was handed over, yes.
Yes. Now the episode has gone. On 4th itself, the FIR was entertained by the same police station and investigation was carried out. Subsequently, charge sheet has been submitted. I have assigned the impugned proceeding on this case.
Where is the complaint of this?
Complaint of this case, lordship, at page
37?
37, yes, 37.
I'll stay this proceeding, servant. The petitioner seeks quashing of GR case number 627 of 2024, pending before the learned Chief Judicial Magistrate, Alipurduar. Paragraph. Learned counsel for the petitioner submits that the petitioner being the registered owner of two vehicles, lent the same to the private opposite party on an informal basis.
Yes.
On an informal basis. Stop, since the private opposite party started claiming title in respect of the said vehicles and refused to return the same to the petitioner, comma. The petitioner filed an application under section 94 of the Code of Criminal Procedure before the learned subdivisional magistrate, comma, Alipurduar, seeking issuance of search warrant. Stop. On a direction given by the learned subdivisional magistrate to that effect, subdivisional magistrate in this regard, comma, search warrant was issued and both the vehicles seized from the possession of the private opposite party. Stop. The investigating officer filed an application before the learned subdivisional magistrate stating that he had no objection to release the recovered vehicles in favor of of their registered owners, Arup Raha, who is the petitioner herein. Stop. By an order passed on April 2024, comma, the vehicles were returned to the petitioner upon proper verification / identification. Stop. On 3rd April 2024, comma, the present complaint was lodged by the private opposite party claiming to have opposite party wherein he claimed that he paid an advance of rupees 6,40,000 and rupees 1,50,000 respectively for purchase of the two vehicles from the petitioner who, comma, despite receiving such advance amount, comma, denied to transfer the title of the vehicles in his favor. Paragraph, it appears from the material on record that the matter needs to be heard on merits. Paragraph, the petitioner is directed to soft copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph, the further proceedings of GR case number 627 of 2024 pending before the learned Chief Judicial Magistrate, Alipurduar, be stayed till 31st January 2025 or until further orders, whichever is earlier. Paragraph, the matter be placed before the next available circuit bench.
Grateful, Lordship.
Next.
21.
Well done.
Yes.
This case, matter opposite party number 1, filed a case against me under section 138 of the NI Act. There is a saying that we petitioner taken money and there is a monetary transaction. I today check, therefore, this was trigger. Therefore, on this, and the opposite party number 1 again filed a case under section 420, 406. There is a dispute. I did not paying the money, and there is a criminal breach of trust. In this regard, there was charge case was registered and charge sheet submitted. I prayed before the learned court, that both the case, section 138 proceeding and the criminal case, both be tried together, and this pair was turned out. Thereafter, I filed an application before the learned additional session judge. This revisional application affirmed the order passed by the learned magistrate. thereafter I pray before your lordship, my lord, that both the cases will be tried together under section 210 of this CRP.
Serve and come back.
For a limited stay
Not necessary. Why do you need a stay? You're on bail in both the cases.
of both the cases, but trial
Let it proceed, serve and come back, next circuit.
only limited. Stay.
Not necessary, not necessary. The petitioner prays for trial of. Tell me the numbers of the cases you have not stated here.
Yes, my lord.
Trial of, GR case number 543 of 2020 under section 406, 420, 34 of the Indian Penal Code, and the complaint case and CR case number 105 of 2020 under section 138 of the Negotiable Instruments Act together. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the next available circuit bench. Next. Yes. Handwriting need not be yours. But you say the judgment has been passed on 21st/11. Oh. Where is the 27th August order? Your prayer was for handwriting expert. Did the opposite party claim that it is your handwriting? They say that it is your signature.
And I also can't see the application, not my claim, my lord. Okay, page 16, the application. There is no one date legally enforceable. My plea and petition. Thereafter, it was taken and thereafter I fill up and apparently there is a
Serve and come back. You don't require a stay. Today we are on 23rd of December. 13th December. Where are those orders? Closure of. It will be for DW, so the matter will continue. It's not getting over, isn't it? Not being disposed of. 2nd January, let's serve in the meantime so that the next circuit can take up the matter. The petitioner is aggrieved by the judgment and order dated 21st November 2024, passed by the learned additional sessions judge, Dinhata, in connection with criminal revision 4 of 2024, affirming the order passed by the learned additional chief judicial magistrate, Dinhata, on 27th August 2024, in CR case number 108 of 2020. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the agenda date. Paragraph, the matter be placed before the next available circuit bench. Next.
I'm for the opposite party complainant.
The accused is also a teacher. You've received the 207 copies? You annex the copies also, 207? Since you are for the private opposite party?
Yes, yes, you are.
I am for the state.
Wait. Who's not doing? Officer, who?
Yes, what does the private opposite party say? Matter is settled.
Your lordship, yes, yes, your lordship.
So come back with the application. Not tomorrow, next Sunday. Because I need to call for, no, because I cannot complete. I have to call for a report from the state. I have to call for a report from the state, record the statement of the victim. That cannot be done in one day. The state has to record. When is you are on bail? Why do you require a state? On January 2nd, the next circuit starts, number one. Secondly, if there is no compromise petition, I would request you to That's not on record. It is going to be filed, not filed as yet. So if that is not filed by under any circumstance, I'll request you to go in for a discharge. A discharge application before the trial, right? Before a quashing, you have good grounds for a discharge. So file your compromise application. I'll record that you want to come back with a compromise application. Approach the circuit 2nd January. Yes. Learned counsels for the petitioner and the private opposite party submit that the dispute between the parties has been amicably settled and the private opposite party does not intend to proceed with the matter any further. The parties seek to file a joint compromise petition in this regard. Paragraph, let the matter appear under the heading to be mentioned on 24th December 2020. Tomorrow to be mentioned. Next.
Well, the next item, my lord, I'm praying for a short passover on behalf of Mr. Vishwajit Manna, my lord. Praying for a short passover, my lord.
Yes.
Mr. Manna is appearing on Monday.
Well, I'm praying
Yes.
for a short passover, my lord, on behalf of Mr. Vishwajit Manna, my lord.
Passed over.
Much okay.
This is appearing for the first time. Very curious case. The petitioner Millard is a 83-year-old lady residing in Mumbai. She has left Kuch Bihar 42 years back and thereafter has never come to Kuch Bihar, nothing to do with the family. Now, Millard, in 2020, Millard, as the record shows, apparently her brother's daughter-in-law preferred an application before the Kuch Bihar court and obtained an interim order that no one can oust her from the residence.
DV Act application.
DV Act application and obtained an interim order that no one can oust her from the residence. Subsequently, Millard, it appears she preferred an FIR under section 31 alleging violation of that interim order, impleading me and other family members who reside in different parts of the country, saying that they have played an instrumental role in ousting her or selling of the property. Now, Millard, surprisingly, it will appear in 2023 that DV Act application itself has been dismissed for default. No final orders passed. And in this FIR, Millard, subsequently, I had no information about it. Charge sheet submitted, warrant issued against me. In my Mumbai residence, now the police is coming saying that, see, this is a warrant which is being issued in your name. I mean, absolutely bolt from the blue. 42 years back, she last interacted with her family in Kuch Bihar. Thereafter, Millard, she doesn't even know who the son of his brother, whom she has married, how she looks like, nothing doing. And Millard, this now warrant is troubling. And Millard, surprisingly, Millard could appear, Millard, the page 40.
Have you obtained bail?
Nothing. I have no knowledge about the proceeding, neither the
No,
DV
no,
Act
after
proceeding
that,
nor
after
this.
the warrant was issued.
No,
have you
no,
obtained
no, no,
taken
Millard.
bail?
I have not obtained because, Millard, I am not in a physical condition to travel. Millard, I am 83 years of age. I have annexed the medical certificate, absolutely in bedridden condition. One of her family members, Millard, a close friend of her in Calcutta, he has appeared before this court and affirmed the petition on her behalf on the strength of her authorization. Page 40, Millard would find the original DV Act alleging violation of which order this FIR has been filed. That has been dismissed for default.
Have you seen this order dated 18th April? it appears that the name of Krishna Bhattacharya is filed forever in the charge sheet.
That
on
was,
account-
no, that was wrong, Millard. The court was under the impression that this petitioner has died.
Yes,
Subsequently, Millard, that has been rectified, charge sheet has been filed in our name. Millard would find the charge sheet. One of the Millard, this Mridula Chakraborty, another relative probably staying in Pune, her name was also there in the FIR, that was filed. Mridula Chakraborty passed away. Krishna Bhattacharya is Millard, the petitioner before your lordship, the only petitioner, who Millard is alive. There is no doubt about it. The charge sheet, Millard, spells my name.
she is a joint owner of that house, a co-sharer.
Apparently, it has been alleged.
Is she a co-sharer?
Millard, according to my instruction, no. No, she has foregone and relinquished her share long
Where
back
is
when
the
she left
order
Kochi.
that dismisses the DV Act case for default?
Millard 40, page 40. Millard, the issuance of warrant, Millard would find at page 29.
I'll stay this quay the petitioner. Please serve and come.
Yes, yes. Only Millard, the warrant be stayed for the time being. What purpose, Millard? 83 years old, Millard, bringing her to Kuch Bihar for nothing.
You don't require stay of the proceeding.
Absolutely, absolutely.
You're asking for stay of the warrant. That's what I'm
Stay
asking.
of the warrant as well as the proceedings. Square the petitioner at least.
I'll do that.
And Millard,
Please serve
something,
in the meeting.
Millard, due to Millard, since we had to approach this court in extreme haste, something, Millard, which we could not annex, but supplementary affidavit I have to take out. Millard, the entire certified copy of the DV Act proceeding we have obtained. The
You want to
entire,
come back with a certificate?
no, Millard, I don't want to. I'm just informing your lordship, Millard, from the records. Millard, this is not a submission from the bar. I'm submitting after seeing the records. My address has been shown in Calcutta while obtaining the interim order, and in entire proceeding, till the time the proceeding was alive, none of the opposite parties appeared.
The proceeding is no longer there.
It's
So,
no longer there.
Yes.
It's no longer there.
I'll record that. The petitioner who is 83 years.
83 years. Millard, I have annexed the medical
The petitioner
certificate.
who is about 83 years old seeks
Millard,
quashing
page
of
16.
83 years old and a resident of Mumbai seeks quashing of GR case number 101 of 2021 pending before the learned Chief Judicial Magistrate, Kuch Bihar. Paragraph, learned counsel for the petitioner submits that the petitioner has been residing in Mumbai for the last
42 years.
for the last 42 years and has no connection whatsoever with her family members in Kolkata.
Kuch Bihar.
Oh, I'm sorry, in Kuch Bihar.
Kuch Bihar, I'm sorry.
A complaint under the Protection of Women Against Domestic Violence Act was lodged by the daughter-in-law of the petitioner's brother, wherein the petitioner has been arraigned as an opposite party. Stop. The address of the petitioner has been wrongly recorded in the said complaint. The petitioner has been addressed the category. The petitioner has been wrongly shown to be a resident of Kolkata, of Kuch Bihar in the said complaint.
Millard, Kolkata. Address has been wrongly shown as Kolkata.
Resident of Kolkata in the said complaint.
Millard, just at the bottom, Millard would find 3 of the opposite parties showing Shield and Kolkata 50, where I never resided.
Where is the interim order?
Millard, the interim order, Millard. The interim order, Millard, is not annexed to the writ petition. Millard would find its reference in the FIR itself. Millard, page.
An interim order was granted in favor of the private opposite party
On 22nd September 2020.
in the said proceeding on 22nd September 2020, directing the opposite parties therein, including the petitioner, restricting the opposite parties therein, including the petitioners, from selling/alienating the property in question where the private opposite party resided, and also from evicting her therefrom. Stop. The proceeding under the 2005 Act was dismissed for default by an order. The page,
40. 31st March 2023 order. Page 40.
by an order passed on 31st March 2023. Stop. The present complaint was lodged by the private opposite party on 26th January 2021, alleging that the petitioner and others have sold out the property and are threatening to dispossess her therefrom. Paragraph. It appears that the proceeding under the 2005 Act has been dismissed for default. Therefore, dismissed for default, comma, meaning thereby, comma, that the interim order granted therein was also vacated. Stop. In any event, comma, the FIR records that the interim order was extended only till 29th January 2021 and not thereafter. Stop. Therefore, the question of violation of the said order does not arise. Paragraph. It appears from the material on record that the petitioner has been able to make out an arguable case. Paragraph. The petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph. Further proceedings of
GR 101 of 2020.
GR case number 101 of 2021, including the warrant of arrest issued against the petitioner therein, be stayed by the petitioner till 31st January 2025 or until further orders, comma, whichever is earlier. Paragraph. The matter be placed before the next available circuit.
Milord, can I make an unusual play? Milord, only Milord, instead of January, if Milord kindly extends it for some more time, because Milord, again, Milord, I have to file an extension if it is not heard.
Let the other side come.
Milord, I have to, Milord, bring
Let the
her,
other side come.
it's
Maybe it is
difficult.
closed off.
Milord, at least till March, Milord. Milord,
Circuit.
only Milord, considering the Milord
circuits
age
in
and
between.
medical condition of the petitioner,
There's
Milord,
no-
I am
There are
making
two
this.
circuits in between.
Milord, at least make it
No.
February, Milord, kindly.
Come back in January, let the other circuit decide.
Great, great, yes. দাদা ওই কাগজটা
Next.
For the state portion.
This is quashing of the proceeding on the basis of joint compromise 406, 420, my lord, monetary
Who
transaction,
is appearing for the private opposite party?
money already paid.
Matter settled?
Yes,
Where is your application? You filed an application?
yes, my lord, application, 10-1. I filed
Can
application.
you come back with a report tomorrow? The state.
State.
No, I would like to request you to record the statement of the de facto complainant. Maybe I need her statement. Because there are prevarications later on. They come and say that I have not signed.
That's right, I can.
Or maybe the signature is under duress.
So Matigara police station.
Can you come back tomorrow? I'll fix it tomorrow night.
Plus one order me kali.
I will, yes, of course I will.
Stated to OC
Let us,
Matigara.
let us give it a try. Learned counsel for the petitioners and the private opposite party submit that the dispute has been amicably settled between the parties and the private opposite party does not intend to proceed with the matter any further. Paragraph, learned counsel for the state is requested to submit a report on the adjourned date, comma, that is tomorrow, bracketed 24th December 2024. With regard to the amicable settlement arrived at between the parties. Stop. The report should contain the statement of the de facto complainant / private opposite party in this regard. Paragraph, let the matter appear under the heading to be mentioned on 24th December 2024. Next. Yes. Why do you require a stay? When is the next date? 6th August is long back. Long back. Yes, we are in December. When is the next date? You are on bail? Over, that is also over. Serve and come back. You don't need a stay. Charge sheet has been submitted, you are on bail. So you don't need any protection. You don't require any protection, right? You are protected. Why it says that you have taken bail, Punu Chakraborty? Panu Chakraborty, Punu Chakraborty is the same. Yes, you are on bail. Please see the order sheet. Serial number 4, 5, 6 are absconding. Oh, 1, 2, 3 on bail. So Sahidul is on bail. Surrender. Surrender and take bail. Allegations are serious, no order will be passed without hearing the other side. And no. Warrant has been issued long back, in April. No, not only, why April? Yes, till December you've managed to abscond, to evade arrest. To evade arrest. So I will not grant any protection, it will be a conflicting order. Yes, come back after service. When is your anticipatory bail before the sessions judge? So I cannot deal with the matter where anticipatory bail is pending. Serve and come back in that case, no further on. The petitioners are directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the next available circuit bench.
File a
Supplementary evidence?
Yes.
Next circuit bench.
Let's
On prayer of the petitioner, liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, the matter be placed before the next available circuit bench. Late Governor, the matter is placed. Next.
Lordship, in this matter, I'm praying for not today. Kindly fix this matter.
Not today means next circuit.
No, Lordship, kindly fix this
Tomorrow I
matter.
will not fix matters, no.
Okay, Lordship, a short passover maybe.
Lordship, I am for the opinion number two. If we wait for the next circuit, then I.
No, Lordship, I will do the matter.
Otherwise.
The
Start
conducting,
making- start your submission.
Lordship, I'm not the conducting advocate, Lordship.
Then how are
Kindly
you
give a,
mentioning this matter before this court?
by my senior's direction. My senior.
Passed over. Great. Next.
Thirdly, Lordship, on earlier occasion, a direction was passed to serve upon the opposite party. Lordship, I served it.
Service effected?
Yes, Lordship, one private respondent, the copy has been returned. Lordship. State has been served.
Lower court record was called for, the trial court record. Why?
Trial court record has called for.
Yes, that's the order. 14th November order.
I didn't check it out, Lordship. I don't know.
It served the state.
Yes,
The last order says upon hearing the petitioner, this court is of the view that lower court record be produced.
I'm holding the CD.
No, I cannot go back, go behind this order. There is a direction. Well, the next bench cannot come and say that no, it is not required, isn't it?
No,
That
sir.
is against judicial
no,
propriety.
exactly.
Private opposite parties.
Opposite party number two is the concerned police officer who has lodged a suo motu case, Lordship. The impugn proceeding, the suo motu complaint was lodged by the opposite party number two. And the opposite party number 3 and 4 are the victim of the same case where
So
the
where is
petitioner
the service on 3 and 4? 3 has, there is no return for 3 at all. And 4 is Aniket Mochari. 1 7.
Aniket Monsari, the
Has
entire
been served.
has been served, yes.
What about the other person?
No, Lordship, she has been, I believe, she has been returned, Lordship. It has delivered to the addressee.
Delivered to the address is 4, no?
Aniket Muchari have returned the consignment.
173 is Aniket Mochari, 173 is delivered.
173 returned.
No,
Aniket Muchari.
173 delivered. The track report says it's delivered.
But the 123, kindly see the consignment returned, that is 173.
How does the track report show delivered then?
Oh, it delivered to the sender, I believe. Kindly see,
Addressee,
addressee.
please see. And but there is no delivery on the 3rd.
No, third,
Please
there is
see
a delivery.
this. Please check this.
Third, there is a delivery. It একটু দিন তো। এই third delivery, another search.
But that's not part of the affidavit.
True, it might be. No, page 7.
5, where is this postal receipt of 3rd?
Postal receipt at the at page 6. Page 5 is the suo motu complainant. Page 5, 6 is the letter, concern letter, and at the top, the postal receipt is there.
Address to the superintendent of district. Please see that. Address to whom?
SP Alipurduar Port, no.
Yes, so that is not the 3rd opposite
Superintendent of
party.
Police District.
I do not find any service on the 3rd opposite party.
The opposite party number
Lakshmi
2,
Mochari.
the state is represented.
No, the private opposite party.
Private respondent Lakshmi Muchari.
Three, Lakshmi Mochari.
Lakshmi.
Where is the service?
Sorry, I need to take instruction.
Since service upon all the opposite parties is not complete. And the trial court record also not produced in terms of the order dated 14th November 2024, the matter be placed before the next available circuit bench.
So if required, then the trial court record will be showed.
I have recorded that. এটা পাঠিয়ে দেবো ট্রায়াল কোর্ট রেকর্ডটা কল করা আছে এটা ডিপার্টমেন্টে পাঠান এটা আমাকে নেক্সট
There is a Passover.
After the list is complete.
My lord.
Lordship, I am for the petition.
In this case, item number 31, I am for the PF authority, Lordship. On Friday, last occasion, I was directed to take instruction about the payment. Lordship, but Friday, Saturday, Sunday, still I have.
No, payment is immaterial. That is irrelevant
Yes,
because
yes,
the
Lordship, that
question
is-
is company.
Compare.
Same
Yes,
here.
yes,
It's the same issue. So
Lordship,
let me
already-
dispose it
al-
off. I have disposed of lot of matters.
Lordship.
Let me dispose this off. Unnecessarily, why keep it pending? Yes,
Lordship, can I my objection? Can you?
your objection will be noted, yes.
And
I'll course the revisional proceeding. I'll
Lordship.
dictate the order later.
Lordship.
The same order will be passed.
Same. Grateful, Lordship.
Basu. Rajiv, এই same order করা আছে। Take it forward. Draft. PF. হ্যাঁ, চলতে যাবে, আপনি বলছেন। শুধু অবজেকশনটা নোট করতে হবে। আর পেমেন্ট হয়েছে ওটা ওই জানতে পারবে।
Along with-
Draft করে আমাকে দিন।
Along with compensation, please. Along with compensation, we have paid. It was 20 lakhs, we paid 24 lakhs, 4 lakhs is compensation. So double your
Since he has not
Lordship,
verified,
Lordship,
I'll not go into that issue at all.
only payment has been
I
done.
will be beyond the
Lordship, Lordship,
payment has been done.
part.
Lordship. Grateful, Lordship. Grateful.
Disposed of. দেখে নিন।
এর আগে সে নাম দেওয়া ঠিক ছিল তো?
Next.
Grateful, Lordship.
Thirty-two. None appears for the petitioner, no accommodation is sought, the matter be placed before the next available circuit bench.
33, I am for the petitioner, Lordship.
33, Lordship.
PF matter.
Which one? 33.
No.
Yes,
Your affidavit of service?
yes, every of service. On 2 occasions also it has been served. Initially, it was the first occasion it has been delivered. Second of the pursuant to the latest order lordship I served it. The track report itself shows that the article is on hold because the door has been closed. So I have challenged the proceeding on the backdrop of a divorce has already been recorded, decree has been passed. Despite the same, the 498 proceeding is still going on.
Service on the private opposite party.
Yes, service has been effected.
Item delivered, yes.
Page 5 and page 6, kindly see.
Yes, it's delivered.
That's it. Yes,
Divorce has been effected.
yes. At page 45.
When was the divorce suit filed and when was the 498A filed?
Divorce suit filed in the year 2022. And the 498 proceeding was registered on on 26th of December 2021. In the charge sheet itself, page 22.
Oh, so first the 498A was
198,
filed, then the
yes,
divorce. So
then divorce.
you cannot take the
No,
plea
no.
that
No,
it was after that.
yes.
Stage of the proceeding, 498.
Stage of the charge
Charge
sheet
sheet
filed.
filed? You're
No.
on bail?
Yes, on bail.
Next date?
Next state lordship.
You have the CD with you?
Yes, I have got the picture.
The last date I find that 13th of June 2024 it was fixed for. But thereafter also I don't have any update.
Since this is a question of quashing,
Yes.
you're asking for quashing, I would request you to make serve a further notice to the de facto complainant and come.
No, lordship, but in the meanwhile, if it possible, stay be passed lordship. Because divorce has been effected, lordship, they are not.
That has nothing to do with the 498A. Since for divorce is a retaliation of the 498A and it's an ex parte decree.
True. But it has not been
So you
challenged.
cannot take the shelter of the
So
divorce.
it has not been challenged,
Has
lordship,
it
number
been
1.
informed?
Yes, lordship, initially it was,
The divorce was informed?
Yes, he didn't challenge it. Divorce in the year, kindly see at page 45, divorce dated 14th of September 2023. Now, more than 1 year has expired. He is not coming to the court.
It was an ex parte decree where the private opposite party did not appear at all.
No, then
We still need to.
subsequently, lordship, pursuant to this proceeding, lordship, I have served twice. Initially, it was delivered to her. He didn't.
No,
She
this
didn't
is-
come.
This is the revisional application that you have served.
Yes.
I am asking about the divorce order.
Divorce. Yes, I have filed a.
So this was behind her back.
No, behind me. She turned up initially. Thereafter, he didn't appear. That's why the ex parte decree was passed.
No, she did not contest at all. Please see the order at page 45.
Page 45. Yes.
It's not recorded that she initially appeared. She did not contest the suit at all.
Husband is able to prove this case and so further submit that petitioner has been subject to
Mr. Luksum, are you aware of the next date?
To the page 46 ex parte degree.
Next date?
Huh?
Next date before the trial court?
Next date, I don't know, because charge sheet has been filed according to the memo of evidence, charge sheet has been filed. So on 22. The year 22 it was filed, my lord.
Unless you can apprise me of the next date,
So
I
I
will not
short
grant a
passport.
stay.
Short passport, I'm giving. Short
Because,
passport.
my lord, we don't know whether charges have been framed or not, because.
That's why I would like to
can
know
take-
the
I'm
next
give- I'm
date and for what.
Short passport. Short passport.
If it's a long date, there are other circuits in between, I'll not grant a
Certainly,
stay.
certainly. So say I'm giving. I'm short passport.
I'll pass it over.
Yes.
Passed over.
Lordship 34 and 35. So he is appearing. Lordship, same issue. Charge sheet submitted against the manager and directors, not against the company.
406, 409.
109, but they have been at the, for state is concerned, I don't know what is, whether the charge sheet, they implicated the company or not, that is not.
We have already filed.
But
Yes, who
state
is
is,
appearing for the state?
state is record party, Lordship.
Who
Lordship,
is appearing?
kindly,
Where is? he?
Lordship, kindly see is page 54. 54. You have got the brief, I think, Mr. PF.
Before in connection with.
Page 54, the charge sheet.
In connection with.
54 is not the charge sheet.
Page 50.
53,
Next,
there is no
P3,
charge.
Lordship.
Here is a 54.
This is, you're seeing what grand? This is the charge. No. This is the charge sheet, yes.
54, it don't know.
এটা অন্য বই দেখছো তুমি সেটাকে 352 দেখো ওটা সিআরআর 352
352, yes.
page 54 annex P3
56 is the annex, P3 56.
oh 56 Lordship Consolidation column number 11 particulars of acquisition charge sheet SL number 1 Ashok Chamaria occupation Tigar estate manager and in 16 Lordship will find it lodged a written complaint against Ashok Chamaria, 2 Rajiv Chamaria, 3 Jagdish Sharma, Sharma of such and such tea estate. So no charge sheet was filed against the company.
No one for the state.
Abhijit Sarkar is in.
Where is he?
In the next item, the case diary is not compliant.
Why do you require the case diary?
We have filed the documents, Lordship. Charge sheet is there.
Charge sheet has been submitted against the company has not been.
Not being added.
14A is a bar. I'll record that none appears for the state in this one. This is not done. No.
You represent.
The court will not wait for anyone. But the affidavit of service code. 34.
34 I have here.
34 affidavit of service, none appears for the state despite service. Oh, it's same provision for none. Third learned counsels for the petitioners and the private opposite party. And the.
Private and opposite party, we are PA for.
Uh-huh.
PA for third. PA for third.
None appears to be. It's same. I'll allow the revisional application and
Both.
quash the both.
Lordship, 35 here.
34, 35.
Only my prayer, my objection can be removed.
35.
My objection can.
Objection will be noted, yes.
Lordship, affidavit of service of 35 I have filed. Grateful, Lordship.
Yes,
Next.
Grateful. 34.
Next, 36.
But I am for the.
Yes, the opposite parties are appearing. Lordship, I am appearing for opposite party number 2.
My lord, this matter may kindly be adjourned, my lord, because the case diary is required.
You're not ready with the case?
No, my lord.
It's under the POXO Act.
Yes, my lord. The allegations are very serious, my lord.
Stay may be granted.
No, my lord.
No, Lordship,
Cannot.
I am ready for the hearing, Lordship. I am ready for Lordship. Actually, Lordship, already there is a direction for expeditious disposal of trial is there. The
Yes,
next date,
sir.
next date